What if I told you that 67% of Americans die without a will or a revocable living trust? That's a crazy statistic, isn't it? And I would venture to guess that a good percentage of that 67% actually owns real property. My name is Sharon Smoot. I'm a realtor and a real estate attorney in the metro Atlanta area. And today I want to talk to you about a new development in Georgia real estate law called transfer on death deeds. So, when I uncovered that statistic that says that 67% of Americans die without a will or a revocable living trust, it immediately made me wonder how many Georgia residents, particularly Georgia real property owners, die without a will or a revocable living trust. And unfortunately, I wasn't able to come up with any hard statistics. What I did uncover, though, is that it is estimated that a majority of Georgia real property owners die without a will or a revocable living trust. It's just insane. So, a lot of people think that wills and revocable living trusts are for rich people, and that couldn't be further from the truth. And especially if you own real estate, whether it's a home or a vacant lot, commercial property, whatever the case may be, if you own real estate, you need to have some solid estate planning so that the state doesn't decide what happens to that property when you die. If you die without a will, a revocable living trust, or a transfer on death deed in place, that means that you have died intestate. When a person dies intestate, the state decides how their property is distributed under the laws of intestacy. And this is true in all states, not just Georgia. So, like I said, I want to talk to you about transfer on death deeds. This is a new development in Georgia. They did not become effective in Georgia. They weren't recognized in Georgia until July 1st, 2024. So brand spanking new, barely a year old. So what is a transfer on death deed? A transfer on death deed allows a homeowner to designate a grantee beneficiary or multiple grantee beneficiaries before their death by executing a transfer on death deed. In that deed, they set forth who their grantee beneficiaries are, and they record that document in the real estate records of the county where the property is located. They are not conveying anything to the grantee beneficiaries at that time. The transfer on death deed is just there on record designating who will get the property if certain things are done once the property owner, the grantor, passes away. So, how does the transfer to the grantee beneficiaries become effective? Well, once the homeowner or the property owner passes away, the grantee beneficiaries, and assuming that there's more than one, there could only be one or there could be multiple, they have to file an affidavit along with a copy of the death certificate of the grantor. The affidavit has to set forth that the grantor passed away, the date of the death, the county of the death, and that the grantee beneficiary, or whether the grantee beneficiary was married to the grantor at the time of the grantor's death. That affidavit, along with a copy of the death certificate, has to be filed in the real estate records of the county where the property is located within 9 months of the grantor's death. If that affidavit is not filed, then the property would have to go through the probate process. If there's a will, then the will would have to be probated. If there is no will, then the estate would have to be administered for the transfer of that property to one of the decedent's heirs. The decedent is the dead person. to take place. If you're still with me to this point, let me know by commenting D. Now, I mentioned earlier that the grantor can designate more than one grantee beneficiary, but there's a very important point that needs to be dealt with. If the grantor is going to designate more than one person as a grantee beneficiary, they need to set forth whether the intention is for those grantee beneficiaries to hold title as joint tenants with full rights of survivorship or as tenants in common. If the transfer on death deed is silent as to how the grantee beneficiaries will hold title, there is a presumption under Georgia law that they will hold title as tenants in common. So let's talk about the difference between joint tenancy and tenancy in common. When two or more people hold title as joint tenants with full rights of survivorship and one of them dies, their interest in the property automatically conveys to the survivors. So if John and Mary own a property together as joint tenants with full rights of survivorship and Mary passes away, John automatically gets Mary's interest in the property. There's nothing that has to be done legally. When John is ready to sell the property, there's an affidavit that he would have to sign that sets forth the facts surrounding Mary's death, that she passed away. This is the date of the death, blah, blah, blah. Sign it, attach a copy of the death certificate recorded in the real estate records, and cross-reference it with the deed where Mary and John were given title to the property, where they obtained the title to the property. It's that simple. Now, when people hold title as tenants in common, it's a little bit more complicated because when one tenant in common passes away, their interest does not automatically go to the surviving tenants in common. Their interest would have to be dealt with via probate or some other estate planning mechanism. So it's really important to understand what the difference is between tenancy in common and joint tenancy, and to adequately designate how you want your grantee beneficiaries to hold title if you are utilizing a transfer on death deed. In other situations where you are conveying property, same thing holds. Do you want them to hold title as joint tenants, or do you want them to hold title as tenants in common? If you add someone to title, and you can check out one of my other videos that warns against doing that, and I'll put it right here somewhere. It'll show up somewhere before the end of this video. You want to make sure, if you want them to get the property when you pass, that deed says that they're going to hold title with you as a joint tenant with full rights of survivorship. And it works both ways. When they pass, you want to get their interest, right? And if you're going to do a tenancy in common situation, I strongly suggest that you have your estate planning in order so that you get to specify who will get your interest, because it could be a situation where some random, relative, maybe it's, Joe Blow, the meth addict, who would be in line to get your interest in the property when you die. Do you really want your co-owners to have to deal with Joe the meth addict? No, you don't. So that's one of the reasons why I love the transfer on death deed. You get to designate. You don't have to worry about going through probate. The people get nothing until you die. There's steps they have to take to get the property once you die. And you get to specify how they're going to hold title once you pass, assuming that they do what they need to do by filing that affidavit along with your death certificate within 9 months of the date of your death. So that is how transfer on death deeds work in Georgia. If you have any questions, feel free to drop them in the comments. If you haven't already done so, please like this video and follow my channel. Have a great day. Thank you.